we can go ahead and get started if y'all are ready, Professor Vladeck.
Sure.
So I will introduce our moderator, Professor Vladeck, although he needs no introduction. Professor Vladeck is the Dalton Cross Professor at the University of Texas School of Law and a nationally recognized expert on the federal courts. He's argued multiple cases before the U.S. Supreme Court and the lower federal courts. Professor Vladeck is the co-host, together with Professor Chesney, of the popular and award-winning National Security Law podcast. He's a Supreme Court analyst for CNN, a co-author of multiple leading law case books, and he has been teaching at the university since 2016, after 11 years at the University of Miami and at American University. A graduate of Yale, Professor Vladeck clerked for the Honorable Marsha Verzon on the 9th Circuit and the Honorable Rosemary Barkett on the 11th Circuit. Take it away.
Cool. Thanks, Seth. Let me just say, obviously, I am not Professor Wasserman. She had to tend to some urgent family matters, and she sends her regrets. I'm sorry for all of you that you were expecting her, and instead you only get me. But fortunately, the panel today has two fantastic outside speakers, and I'm basically just going to briefly introduce them and then get out of their way. So first, we're going to hear from Professor Jennifer Koh, who's an assistant professor of law at the University of California, Irvine School of Law, and also wearing two hats this semester, also the visiting professor and director of the Immigration Clinic at the University of Washington School of Law. That is some impressive double duty. And Jennifer has her bachelor's from Yale, her JD from Columbia Law School, and is a widely recognized expert at the intersection of criminal law, immigration, and related justice concerns. And then after Jennifer, we're going to hear from Chris Walker, who is the John W. Bricker Professor of Law at the Moritz College of Law, at a school that I am genetically predisposed to not identify out loud. But fortunately, Chris has provided background pictures in case there was any doubt. And Chris obviously is a nationally recognized expert on administrative law. And so for the topic, DACA and the administrative state, what's next for recipients and policymakers, we really have two of the leading authorities on DACA itself and then on administrative law more broadly. And so I am going to stop there. Jennifer's going to go first, Chris is going to go second. I'm then going to ask them some annoying comments in the form of questions. And then, time permitting, we'll throw it open to some student Q&A at the end. So, Jennifer, welcome and take it away.
Great, thank you, and thank you for having me. So I'm just going to go ahead. I'm sharing my screen in the hopes that you can all see the PowerPoint that might allow us to follow along. Give me just a second because I am filling a tiny bit. Okay. There we go. All right, well, thank you for having me. I'm going to frame my comments briefly around the past, present, and future of DACA. And there are three series of questions implicated by asking a question about what has happened with the past, present, and what can we expect to happen with the future of DACA. With respect to the past, how is it that DACA came to reflect these contests between legislative and executive power over the meaning of social costs and benefits in immigration law, and even between law and morality? With respect to the present, when I say the present, I'm really referring to the Supreme Court's decision in DHS versus Regents. How did that decision reframe, affirm, but also avoid some of those issues? And with respect to the future, where do we go from here? And the we here may include DACA recipients and their communities, may include the national community and how we engage with and grapple over immigration law, as well as the future of the administrative state. So first, let's just talk a little bit about DACA's past. The existence of DACA was preceded by the existence of a growing population of young people in the United States known as Dreamers. And to some of us, this history is fairly familiar, but I think it bears mentioning to frame our conversation today. Dreamers are generally known as immigrants who came to the United States as children, often whose only home was the United States, but who had no option under the existing immigration laws to fix their undocumented immigration status. Generally, Dreamers had grown up in the US educational system, learning foundational American values, things like freedom and democracy and the ability to affect the laws towards greater good. And yet their own lives exposed a sharp disconnect between the law and their underlying intuitive sense of their moral claims to membership in the United States. Because again, the existing laws on the books, for many of them, simply offered no option for legalization to fix their status. And so the initial goal of the Dreamer movement was legislative reform. For years, communities organized to advocate for a piece of legislation known as the DREAM Act. The DREAM Act was first introduced in Congress almost 20 years ago, and the DREAM Act would have provided a pathway to lawful permanent residence and eventually to citizenship for young immigrants who came to the United States as children. But for years, the DREAM Act failed to move forward. Opponents raised a number of concerns, often amounting to the concern that passing the DREAM Act would constitute an unacceptable form of amnesty that would incentivize future unlawful migration. And so, for example, in the image you see on the left from 2010, there was a filibuster in the Senate that would have required a vote of 60 to overcome. And in many ways, 2010, 2011 were seen as the death of the DREAM Act or possibilities for the DREAM Act. And so as it became clear that legislative advocacy was unlikely to succeed, the focus turned towards other potential avenues of change and towards the executive branch, to President Obama, who was then in office, and the potential for regulatory or some kind of a change or some kind of executive action. And so that took us to DACA and to June 15th of 2012. And on that day, then President Obama announced the creation of DACA. The creation of the program itself occurred via memorandum. And we'll see a series of memorandums as we kind of trace the trajectory of DACA up to the present and the future. And so then DHS Secretary Janet Napolitano issued a memo that created a form of categorical prosecutorial discretion for a class of non-citizens, and based on qualifications like age at the time of entry, age of the person at the time, physical presence in the United States as of the date of the memo, and other qualifications, for example, related to the nature of one's potential criminal history. It created a set of qualifications by which a person could apply and be designated as having DACA status. Now, the phrase DACA was invented in 2012, but the phrase deferred action was not at all just sort of invented out of thin air. In fact, the phrase deferred action had existed in the immigration law and had a statutory and regulatory scheme associated with it. So for example, I represented non-citizens who were survivors of domestic violence, who were seeking to petition for their lawful status for a number of years. And many of them, because of long administrative waiting periods associated with the process, would receive this thing called deferred action. The way I would often explain it to clients then was that, look, the government knows you're here, but is choosing not to prioritize your case for deportation. So under the existing designation of deferred action, a person with deferred action could receive work authorization and associated benefits that would flow from work authorization. DACA kind of slipped itself into that existing scheme. Again, applicants would pay a fee, complete an application form, submit supporting documents, and receive both work authorization as well as a designation from the government that they had DACA and were therefore a low priority for deportation. This was a lively time in many immigrant communities. At that time, I worked alongside organizers and attorneys in Orange County, California, and held DACA clinics and educational sessions, and can still remember being in large, overflowing, stand-only rooms that were filled overwhelmingly with a feeling of hope just emanating from the people who were in attendance. Let's fast forward just a couple of years to 2014, because as young people who had been identifying as dreamers were receiving this designation of DACA, there really began to be a questioning of the narrative that the dreamer movement had pushed. The narrative had often been, look, we are young people who were brought to the United States through no fault of their own or of our own. And many began to question, well, whose fault is it? Are we blaming our parents? Is the fault of our parents then one that should be juxtaposed against our innocence? And for both those reasons, as well as other, an understanding that, again, legislative comprehensive immigration reform was unlikely to happen, advocacy on the part of immigrant communities led to the creation of something called DAPA, Deferred Action for Parents of Americans and Lawful Permanent Residents. DAPA, similarly created by memo, would have extended a similar type of safety from deportation and work authorization benefits to parents of US citizens and lawful permanent residents. And this is in many ways where the litigation journey begins. DAPA was never actually conferred upon any person. And in addition to DAPA, there was also an expansion of the eligibility requirements associated with DACA. Instead, the state of Texas and 20 some other states filed suit in the Southern District of Texas, and that lawsuit resulted in a national injunction against the implementation of DAPA and extended DACA. That injunction was then upheld by the Fifth Circuit. The main bases for this injunction were the courts holding that at the preliminary injunction stage, the states were likely to succeed in their claim that DAPA should have gone through the notice and comment procedure that the Administrative Procedure Act requires for certain types of government action. And the court also held that DAPA's extension of benefits, that the work authorization and associated benefits were likely to succeed as a violation of the statutory scheme, as a violation of the existing immigration statutes on the books. There was no explicit finding, really no finding at all, with respect to the original DACA program. And there was no finding that the particular feature of DAPA or extended DACA, the particular feature of forbearing deportation and choosing to put someone low on the list for as a priority for deportation, there was no finding as to that being unlawful. Okay, that Fifth Circuit decision went to the Supreme Court. Hundreds of pages of briefing were presented. The decision was highly anticipated, and what you see on the upper right-hand corner is what the Supreme Court returned, was a single member opinion that said that the judgment is equally affirmed the judgment is affirmed by an equally divided court. The court at the time consisted of 8 members, and that was due to the stalled nomination of DC Circuit Judge Merrick Garland. In 2016, we had an election, and President Donald Trump was elected. And so some months into the administration, then Attorney General Jeff Sessions announced that due to concerns regarding the legality of DACA, and this was in reference to that prior lawsuit, that the administration would be rescinding the original DACA program. Now again, the announcement itself is not what rescinded DACA. It was a memo issued by then acting DHS Secretary Elaine Duke, who, acting on the advice from the Attorney General, issued a memo explaining that DACA would be rescinded, and another wave of litigation followed. So that takes us to the present, to the Regents' decision itself. And I know Professor Walker will speak more about the content of the decision. I'll just highlight a couple of quick pieces of it, really the main holding. So in a 5-4 decision, and really in a surprise to many who had followed the oral arguments and sought to read the tea leaves during the oral argument exchange, Justice Chief Roberts served as the deciding vote, and the court vacated the DACA rescission. The court held that DHS's attempt to rescind DACA was subject to judicial review, and that more importantly, under the Administrative Procedure Act, the rescission itself constituted an arbitrary and capricious government action and is therefore invalid. Now again, the court, and it's important to understand, the court didn't take a position on necessarily the propriety or legality of DACA itself. As the court put it, the dispute before the court is not whether DHS may rescind DACA. All parties agree that it may, but the dispute is instead primarily about the procedure the agency followed in doing so. So the requirement, this procedure goes back to the arbitrary and capricious doctrine. The prohibition on arbitrary and capricious agency action has solid grounding in administrative law. For those of you who have taken administrative law, you've no doubt read the State Farm case, which says that government agencies must engage in reasoned decision-making when they act, and that when an agency fails to consider an important aspect of the problem before it, it falls short of that requirement. So what was it that the Duke memo failed to do? The court found that, that the Duke memo failed to consider an important possibility for the rescission of DACA, that what the government could have done was rescind only the benefits portion of DACA. The government could have done away with work authorization, could have done away with associated benefits, and could have instead simply kept the promise not to deport, to put people lower on the priority list for deportation. By failing to consider that possibility, the court said that the memo failed to consider an important aspect of the problem. And one reason that was important to make that distinction between benefits versus forbearing deportation, again, had to do with the nature of the findings in that earlier Fifth Circuit litigation. The comparison that the court made, if you've studied the State Farm decision, is that the failure to consider forbearance only, to not deport only as an option for DACA, was somewhat similar to the State Farm decision not to, for the administration's failure to consider airbags only as an option for an automobile industry regulation. In addition, the court noted that the administration failed to consider the ways that DACA recipients had come to actually rely on the program as part of their livelihoods and their plans for the future. And so as the court put it, quoting the UC Board of Regents brief, since 2012, DACA recipients have enrolled in degree programs, embarked on careers, started businesses, purchased home, and even married and had children, all in reliance on the DACA program. By the administration, through the Duke memo, not fully considering and discussing those reliance interests, again, the threshold requirement that the government act in a manner that is not arbitrary and capricious was not met. Okay, I'd like to just wrap up quickly, but I'll share a couple of quick updates and thoughts on the future. So in the wake of the DACA decision, commentators and people following this decision widely understood that the SCOTUS ruling really meant that the prior DACA policy in existence prior to rescission would be restored. And so, for example, people who had never applied for DACA before and were not able to, would then be able to file new applications. But the day after the Supreme Court's decision, USCIS, which is the agency responsible for adjudicating DACA applications, announced its belief that the Supreme Court's decision had no basis in law. And then about 6 weeks after the decision, Acting DHS Secretary Chad Wolf issued another memo stating the administration's plans, describing their plans to reconsider DACA, but announcing that in the meantime, no new applications would be processed, and that going forward, work permits, for example, would have their time period shortened from 2 years to 1 year. This has now set off a new round of litigation. So since the Supreme Court's decision was issued, a district court in Maryland directed the administration to implement the Supreme Court's decision. A complaint has since been filed challenging the legality of this July 28th memo, alleging both arbitrary and capricious claims, but also introducing a new wrinkle into the future of DACA, which is an allegation that acting DHS Secretary Chad Wolf was unlawfully appointed to his position as head of the agency, both in violation of the Appointments Clause of the Constitution, as well as statutory limitations and requirements in place governing the appointment of agency heads. And yet another wrinkle, on Friday, in unrelated litigation, a district court judge in Maryland found that an appointments challenge to Secretary Wolf was likely to succeed, and therefore issued a limited injunction of unrelated asylum rules that Secretary Wolf had issued. And so at the end of the day, really, much of the fate of DACA holders will rest on the results of the November election. The underlying debates over how we move forward and dialogue and address these challenges, those really remain up to all of us. But I'll stop here and we'll hand the mic over to Professor Walker.
Great. Well, thank you so much, Jennifer, for setting the table so well and explaining the context for this, and thanks to Professor to Steve as well for doing this, for moderating and jumping in when Melissa had to step out. I'm gonna just focus on my remarks on just two points. I'm gonna do a little bit of a deeper dive into one part of the DACA rescission decision from the Supreme Court. And then I'm going to talk more broadly about why this is just a really, really bad way to govern immigration in our country by doing it through executive order, executive action, as they did here. And so just to kind of give you a little bit of a sense of what's going on in DACA, in the DACA rescission case, when the case made it to the Supreme Court, putting aside, there was an equal protection claim that said that the way that this was violating the Equal Protection Clause. Putting that aside, there was no real debate or dispute that a president could rescind a program like DACA if they did it in the right way, as Professor Koh was kind of going through. In other words, as long as they complied with the reasoned decision-making requirements of the Administrative Procedure Act, issued a decision that could withstand scrutiny under judicial review from a reasoning and process perspective, that this program could be rescinded. And so what was really being looked at in that case, and what I want to talk about now, of course, the court also had to ask, can we even review this? Under the Immigration and Nationality Act, certain actions can't be reviewed. Under the Administrative Procedure Act, agency discretion decisions cannot be reviewed either. And so you have these kind of other issues lurking in the background that the court ultimately was able to say, no, we can review this because there are aspects of the decision that aren't discretionary. And the Immigration and Nationality Act restrictions on review don't prohibit us from reviewing the DHS memo, although they perhaps prohibit us from reviewing the Attorney General memo that was kind of the underlying cause. So what we're looking at in the case, if you kind of go, is this Duke memo, as Professor Koh mentioned, that was issued by acting Secretary Elaine Duke. And if you read the memo, it's on the government's website. There's not much there. There's 4 or 5 paragraphs of like introductory preamble that summarizes in large part what Professor Koh already did, that there's been litigation and the like. And then before it gets into how it's going to wind down the program, I think you have 1 paragraph that's really the reasoning behind why DHS was doing this. And all it says, taking in consideration the Supreme Court's and the Fifth Circuit's rulings in the ongoing litigation, I've decided to unwind this. Now, if you go through the rest of the memo then did carefully, it didn't end the program. It stopped taking new applications and allowed for people to apply for a certain amount of time. And I mentioned that because I do think that the memo reflects some consideration of the reliance interest of individuals who already received the deferred action through DACA. But that's it, right? There's not a discussion of, did they look at other alternatives? Did they think about, is this a policy decision? Is it a legal decision? The lower courts generally read this as a legal decision. In other words, that the DHS acting secretary decided that she did not have, the program was unlawful and had to be, ended because of that, not because the administration decided as a policy matter to do something different. And so as Professor Koh mentions, when the Supreme Court gets this, and once they decide they can actually review the action, that it's not just discretionary. And in the Q&A, we can talk more about that. It's interesting how Chief Justice Roberts, writing for the court, reached that decision. But as Professor Koh mentioned, basically it's just two reasons why it's arbitrary and capricious. The first is that the acting secretary failed to explain why she didn't explore an alternative. Now, maybe Professor Vladeck, Professor Koh would disagree with me. This, in my mind, kind of came out of nowhere. There were a few paragraphs and a couple different briefs. But what the Supreme Court ultimately said was, when Attorney General Sessions said that this program was unlawful, it was referring to the conferral of benefits under DACA, not to the decision to forbear removal. In other words, there are two separate things going on in DACA. One, there's a promise to forbear or to not remove for a certain amount of time. And two, there's a conferral of certain benefits that come with that deferred action, work benefits and the like. And so what Chief Justice Roberts said was what Acting Secretary Duke should have done in response to Sessions' memo was to say, I'm still going to decide whether to forbear. I can't decide whether to confer benefits, but I could decide whether to forbear now. How that could actually happen is a much longer story. Arguably, you have to go through notice of comment rulemaking and change some regulations because the benefits automatically conferred with the forbearance. But that's really kind of the crux of the argument in my mind for why it's arbitrary and capricious. And I want to flag for administrative law nerds, if we're allowed to look at alternatives that aren't even really raised by parties when we're reviewing agency action, that's really going to be interesting to see how this is applied in future cases, because agencies a lot of times don't consider all the alternatives, especially alternatives that actually aren't raised by the parties. And then the second one, as Professor Koh already mentioned, is that the Duke member failed to adequately consider reliance interest at stake. You saw the paragraph, there's not much there. The government did make a pretty decent argument that by winding it down and not ending it, that should be evidence that they considered some of the reliance interests. But what I want to focus on real briefly is what the court refused to consider. So in some of the litigation in the DC District Court, the DC District Judge actually ordered, or better said, I'm going to reach the same decision all the other courts did and find that this was unlawfully rescinded. But before I make that effective, I'm going to allow the new Secretary of Homeland Security, Kristen Nielsen, to actually tell me if there's something more. This is a standard move in administrative law where courts can actually remand without vacature. They can say, hey, we think your reasoning is wrong, agency, or we don't think it's sufficient. You need to provide more reasons. And so they send it back to the agency to reconsider. Secretary Nielsen issues a new memo, and you can go look at it on the DHS website, and walks through the reasons for continuing to decide to rescind DACA. The first two reasons are similar to what we had before. DACA is illegal, says Sessions. Serious doubts about legality, which is actually a policy reason. We don't want to continue a program that's legally questionable. And then, in my mind, she goes forward and puts forth a number of kind of classic enforcement policy reasons for not continuing the program. Congress, not agency, should be the one that makes the broad classes, categories, and non-enforcement. And DHS wants to send a strong message at the border of a clear, consistent, transparent enforcement of immigration laws. In the last paragraph, she then says that she walks through and talks about how she's considered all the reliance interests, that she recognizes that individuals have relied on and that their lives are going to be uprooted by this decision, but ultimately decides that the other reasons for doing this outweigh that. Justice Kavanaugh, in his separate concurrence and dissent, says this is more than enough to uphold a rescission of DACA. I haven't seen many people argue that it's not. If this was an actual new decision or if it were an articulation that added to the old decision. What did the court do? The court said, we're not going to consider this. This is a post hoc explanation for the original decision. And I think this is actually a really somewhat of a hard question on that front, because the Nielsen memo does a dance between saying, I'm issuing a new decision, and I'm making my own decision as a matter of enforcement policy to rescind DACA, as opposed to the agency, Nielsen just kind of saying, I'm not going to disturb it, right? So here's one half of the dance. I declined to disturb the Duke memorandum's rescission. I'm explaining why this remains sound. The flip side is at the very end, in my mind, it seems to say I'm making my own decision in setting DHS enforcement policy priorities. I concur with the decline to disturb acting Secretary Duke's decision to rescind DACA. Seems to me like it's an independent decision. If it is an independent decision, then we kind of start all over again. And this is the order that we need to evaluate to decide whether it complies with the Administrative Procedure Act. And that's a much harder case to make in order to defeat kind of the administration's approach here. If you want to read more about that, the Kavanaugh separate opinion kind of goes through that a bit more. I'm happy to kind of talk through this more in the exchange back and forth. But it is an unusual case of not looking at additional, at the new memorandum, either as a new standalone action, which no court did, or as at least under the remand without vacature approach in administrative law, a chance for the agency to provide additional reasons for its action. Okay, so I'm going to go real quickly, and because I want to get to questions. And the kind of larger issue here, and you saw this in Professor Koh's explanation of the background, is this approach of making major policy decisions through executive memorandum, I find to be a particularly problematic one. Hopefully in your constitutional law class or your administrative law class, you learned about these three branches of government. They're all supposed to be doing different things, with Congress legislating, the executive branch implementing the law, and the courts saying what the law is. You hopefully learned, or in high school and college and in law school, about checks and balances, how the Constitution has these set up in the process. You may have watched at some point the Schoolhouse Rock video that explains in a very oversimplistic fashion how laws are made in the United States. And hopefully you've spent some time thinking about how this whole tree metaphor in the Constitution really doesn't represent what we do today. And in particular, just the role of the modern administrative state in this process. Federal agencies exercise essentially some form, all powers that all three branches have, whether that's making major policy and laws through regulation. Obviously, this is the branch that the president mostly controls to execute the law, but they also do a lot of adjudication in the immigration context in particular. So they have this kind of uncomfortable spot that doesn't fit in with our Schoolhouse Rock's version of the three branches kind of each having a separate role. And then on top of that, you have the idea of presidential power. And if we have more time, as I do in my legislation regulation class, after, I start out the semester with Schoolhouse Rock's How a Bill Becomes a Law, and then I kind of go to How a Bill Not Becomes a Law, the Saturday Night Live version of this. And this is dealing with DAPA, not DACA. but just this idea that you can kind of bypass Congress to make major decisions, can be viewed as problematic. And I don't think this has to be particularly ideological in the sense of that we should want Congress to make the major laws and not the president to do it without Congress. Although I recognize in this context, the stakes are high and it matters a lot of the outcome that the Congress has not acted on immigration reform for a long time. But I kind of want to end with what President Trump did after Congress refused to pass any type of COVID relief in this last wave of kind of COVID stimulus, where he did, I think, something very similar to what President Obama did with DACA and DAPA, and tried to use existing authorities to provide economic relief for those that are suffering significantly from the COVID epidemic. And some of these might have good policy justifications, such as expanding unemployment benefits and providing some payroll relief. There's some argument about whether they're allowed under the statute or not, similar to how there are arguments about whether DACA and DAPA are allowed under the statutory framework that exists. But I would kind of just end by saying, this isn't the way that our country is structured to work, where we resort to executive power when Congress has refused to act. And maybe the answer that we should not do nothing is not satisfying to me. The answer that Congress should start doing something to reclaim its proper role in making policy is kind of where I think we need to be going as a country. And I think I'll end there and turn it over to Steve.
Great. Thank you, Chris. Thanks to both you and Jennifer for those presentations. I have a couple of questions I want to put to both of you, but let me sort of take the chance now to encourage the folks who are watching, please take advantage of the question and answer feature to pose questions, whether to either the panelists, to both of them, to all three of us. And I will curate the questions that are posted there as they come in. Chris, I guess my first question is I want to sort of go back to the sort of Kavanaugh's opinion in the Regents case, because I want to sort of push back a little on the suggestion that the subsequent Nielsen action really does sort of take over as an independent justification for the rescission. Because I want to sort of put it a little bit more broadly as if you were a DACA recipient, right? Would you have, do you think that the average DACA recipient would have understood the Nielsen memorandum as somehow different in kind or degree from the Duke memo? Because it seems like part of what is offending the Chief Justice in his majority opinion is the notion that the government was talking out of both sides of its mouth. And shouldn't we care, at least to some degree, right, how the government's actions are perceived by its purported beneficiaries in this context? Because I read the Duke memo, I read the Nielsen memo, I see how one could find the Nielsen memo to do what Kavanaugh says it does, but I also see how an average person on the street might think that it was just, oh yeah, Duke said that and I don't disagree, the end. Like, is that relevant at all?
Yeah, I mean, this is the dance I was referring to a little bit, right? And then to back up, I want to, and I think, Steve, you'll agree with me. I think that the original decision was very strategic.
Yeah.
I think that Sessions, I don't know the whole backstory, and there are lots of different conspiracy, lots of different ways it could play out.
No,
One
it's
is that
right.
maybe Trump didn't want to get rid of DACA, liked it as a policy matter. Another is that they didn't want to have to pay the policy costs of getting rid of DACA, which I find probably quite persuasive, right? It's a classic move in the Trump administration to say, we just don't have the legal authority to do what you want us to do.
Our hands are tied. We don't want to do it. Someone's making us.
We want to do it, but we can't, right? And so we've got to kind of strike it down. So I definitely think that's at play there. Jennifer New at Chicago has another theory, a deep state theory. This was an acting secretary that apparently did not agree, maybe, with rescinding DACA as a policy matter. And so she refused to actually make policy arguments. So lots of different reasons why, but I think we kind of all agree that this was strategic for one reason or another, not to actually put forward policy reasons. And so when the Nielsen memo comes out, there are two different ways to read it. And when I was first reading it, I thought of it, is this a standalone decision or not? Is this a new agency action that would start the process over again? And I think that's that's where the dance comes in. I'm not sure. I think sometimes she says this is her own decision, sometimes it doesn't. But I think the harder decision that Kavanaugh gets at is this a remand without vacature? I think it is. I don't think there's any way to get around it. The court says, agency, the reasons you gave aren't enough. I'm going to let you give better reasons, more reasons. And if you give more reasons, I'll then evaluate it. And I think that's exactly what Nielsen did. I think she gives policy reasons that are clearly not in the Duke memo, but they still represent the position of the agency as a whole. And at that point, Judge Bates should have considered that memo and considered the reasons given in that memo. And if he had, I think DACA would have been upheld, the rescission would have been upheld at the time. Now, does the ordinary person understand that? I don't know. I mean, does the immigration lawyer understand it? Yes. Maybe Jennifer would disagree with me. Does the administrative law professor or scholar understand it, or practitioner? Absolutely. I mean, this is pretty standard approach to remand without vacature, that when an agency issues another decision, you've got to consider it.
So I guess, I mean, Jennifer, I want to sort of throw the next question to you, but let me sort of say, I mean, in that capacity, is it possible to understand the DACA decision, the Chief Justice's opinion, as sort of a class of two, right, along with the census citizenship case from last year, where it's a move that under ordinary principles of administrative law, the government would have been allowed to get away with. In the census case, the court actually expressly holds, right, that under ordinary circumstances, the government can get away with it. But where there's just such a sort of stink of strategery, right, that the Chief Justice is sort of offended by the notion that the government's trying to pull a fast one. And Jennifer, if so, what kind of precedent is that?
It's a great question, right? Because I think that's right? I mean, in some ways, you could take the census case and you could take the DACA case and say, this is the court expanding arbitrary and capricious review, taking this already fairly capacious doctrine and, setting precedent that then, prevents future administrations from engaging in any kind of meaningful or efficient change in policy, when in fact that's exactly what we intend from changes in presidential administration, is the flexibility to make changes in policy. And I think in particular, the census case kind of reads as this like example of extraordinary circumstances that, right, with like the withholding of information and the false representations just might be cabined to its own terms. I think that's possible here as well. I mean, as always, like, we don't know, but certainly the DACA decision itself was also, carefully crafted, that it was a decision where, as I alluded to earlier, Justice Roberts's supporting vote came as a surprise. And so it does have the feel that there were some kind of just special considerations. It wouldn't be surprising to see the court in the future just say, look, we're limiting that case to X facts. We're limiting it to some extraordinary circumstances. Maybe there is some broadening of the or a tightening rather, in terms of the post hoc rationalizations and what we expect of the government in terms of giving justifications for its actions. But I do think it's possible, right, in terms of that broader effect, without necessarily having a crystal ball into the future. Certainly with respect to immigration law, it's going to go down in history. It will occupy an important place in terms of creating our just sort of overall jurisprudence. In particular, I think, Chris, you mentioned this, there was an equal protection claim that had been in the lower courts, and equal protection was one that the court did not support, right? Aside from Justice Sotomayor's opinion, the court was not willing to allow those equal protection claims to go forward. That certainly has repercussions for the future as well. It's certainly consistent with what the courts have done, but it does kind of connect a bit, Steve, to your point about sort of to what extent is what the government does resonate with the people who are most affected. You know, in speaking with some of the plaintiffs who had been part of the DACA litigation, you know, many of them, I think, left the oral arguments in the DACA case saying, like, what was that about? Right? Like, we know this case to be about our lives, but what was that argument really about? Certainly equal protection did resonate and would have resonated more powerfully. But by choosing arbitrary and capricious review, this technical, sort of hard to understand for the ordinary person, you know, that has its own implications as well for these debates.
So I should say, I mean, I was in the courtroom for the DACA argument, and it was a very, the government side of the argument versus the sort of respondent side were two very different vibes. So one more question about precedent, and then I want to throw it over to the students. There's already one question in the Q&A box, and I hope the students will submit some more. So Chris, I don't know if you saw John Yu's piece in the National Review about the DACA decision, but John has been arguing for the better part of the summer that the DACA decision gives future presidents enormous power to basically do things that are unlawful and then sort of entrench them in ways where they can't be rescinded by future presidents. And I guess, you know, I'm curious if you agree that the decision is a roadmap to mischief by future presidents, or if you see, you know, what mischief it causes, especially to Chenery, in perhaps less dramatic terms.
Yeah, I mean, so I don't buy that. I mean, one, it's a Chief Justice Roberts special, right? I mean, it's written in a way that is good for this day only. I mean, there are lines in it that no doubt when I'm filing briefs on behalf of the U.S. Chamber of Commerce, I will be using them, like reliance interest, considering alternatives and the like. But the idea that you can do this through executive action, I mean, I'm sure what Chief Justice Roberts thought was, come on, you know, DHS, if you're going to do this, do it right out, make it public, pay the costs, reap the benefits with your, you know, there are costs and benefits politically for doing this. And if we got it wrong, like 2 hours after the decision issued, you could issue a new memo. And you know, like that's very different than this, right? And I do think, although we don't get into the weeds of this, the Chief's way to focus on the part of forbearance and not the benefits by separating that out really makes this case, in my mind, very hard to apply. The arbitrary and capricious part, hard to apply beyond this case. The remand without vacature, I'm really curious to see what lower courts will do. I think there's a pretty good chance that we might not have remand without vacature anymore. That generally benefits, you know, it has a weird effect on, you know, a lot of times regulated entities want to challenge a rule because they didn't think it goes far enough. But if they're worried that the court says, yeah, you're right, it doesn't go far enough, we're vacating the whole rule, think like anything that deals with like the environment, you have to start over agency. There's no rule for the next 3 years as you come up with something new. I think that's kind of the scary part that could happen from that. We'll have to see what lower courts do. But no, the U approach that somehow the presidents are going to lock it in, I mean, Steve, maybe you have better examples. I can't think of an example where that would actually happen. It's not DACA. I mean, I think the Nielsen memo was probably enough for the chief, and that's why he refused to consider it. So,
yeah, but I think John. I mean, I have to go back and read the piece, but I think John's proposal was something along the lines of some kind of regulatory entitlement to various gun protections that might go beyond the Second Amendment, and sort of write the regulation in a way that makes it hard to rescind without some kind of. Anyway, I don't want to put words into John's mouth, but I do think it was a theme we heard a lot over the summer about folks trying to portray the DACA decision as actually a huge victory for executive power, and I guess I just don't see it, right? I mean, if anything, you know, it may be a very modest constraint, Chris, to use your term, right? A John Roberts special, but yeah. All right, we have a couple of questions in the queue, and I don't want to take up any more of the students' time. So the first question, Jennifer, I'm going to frame to you. This is from John Goodman. how much have immigration courts considered factors like school performance, letters of recommendation, et cetera, when deciding cases with children under DACA?
Great. Yeah. So it's a great question. It's an interesting one. I want to unpack it just a tiny bit to reflect the kind of assumptions that I'm going to read into the question that may or may not be correct. Because I think when the question asks, how have immigration courts considered factors, then I'm assuming that we're talking about people who are being already charged with deportation, who are in removal proceedings and are before an immigration judge, and are actually trying to defend themselves from deportation. And I think when the question is asking, like with children under DACA, we're talking about people who might qualify for DACA, people who fit the profile of a DACA holder. And so the short answer to that is, generally speaking, the courts don't consider it. In terms of the law and what the law provides, when a person is facing deportation, their defenses are very limited. And so it is only in select circumstances where, if a person otherwise qualifies to be able to present a certain type of defense, where something like a school performance or letters of recommendation might make a difference as a discretionary matter, then immigration courts might. But there are a whole host of cases in which a person will go before an immigration judge, and even if they are more or less fit the profile of a DACA holder, where the judge will just say, look, you're not eligible for relief. There is no discretionary argument to be heard because you don't have a right under the law to raise that, and so you are hereby ordered removed. I mean, certainly people who are otherwise DACA eligible are and have been placed into removal proceedings and deported and detained as well during the pendency of those proceedings. So I hope that answers the question. I'm just sort of reading it fairly literally in terms of the way it was posed.
Sure. Chris, I'm gonna put the next one to you first, although I think we might all three have things to say about it. This is from Austin Nelson. Can we say a little bit about what we make of Justice Thomas's symmetry argument in his dissent, where he was joined by Justices Alito and Gorsuch? And Austin quotes the relevant language. Let me just quote the end of it. To state it plainly, the Trump administration rescinded DACA the same way the Obama administration created it, unilaterally and through a mere memorandum. So I guess the question is, what do you make of it? And I guess I might put a little more spin on that, Chris, to say, did you find that particular argument convincing? And if so, why? And if not, why not?
Yeah, well, this is one of the frustrating parts of the Chief's opinion. And I think there's a lot in Justice Thomas's separate opinion work that has to be right. Again, we're getting way too much into the weeds of what happened here. But remember, the Chief, Attorney General Sessions, looked at DACA as a program and determined that it was illegal, right? The whole program. And one of the reasons why is because it gave benefits to individuals as a class as part of a forbearance policy. The Chief split those out. Now, why did it give benefits? That's not because DACA created the benefits. That's because the regulations that went through notice of comment rulemaking for the deferred action, that, as Professor Koh mentioned, existed long before DACA, they triggered benefits, right? That the forbearance did this. And so one of the things that I think one of the things, maybe I'm reading too much into Justice Thomas's opinion, but I don't think I am, that he's frustrated with is like, hey, Chief, you're saying that basically if you want to unwind this program, you have to go through rulemaking and get rid of the benefits that are triggered by deferred action. That's locking in a program. That's not right. Attorney General Sessions looked at this and wanted to divide this out. And he didn't want to divide it out. Wanted to say that the DACA manual, because of the regulations that existed, was unlawful. And I think there's a lot to that. And I don't know, maybe Professor Koh has, a different take on that. But on kind of the larger point, I do think it's worth underscoring, on that last sentence that Steve, quoted, is that there's no dispute that DACA can be unwound by mere memorandum, unless it's an equal protection violation. But that only got one vote, as Professor Koh mentioned, right? There's no dispute that they could have just said, we understand that we can do this, we can forbear, but we're choosing not to for policy reasons. And I think that's like something that I know that I know where Justice Thomas is going with this and why he's frustrated, because he thinks the chief has made a move that's really cute, that wasn't really briefed fully and kind of teed up. But the flip side is, I worry, and I'm now seeing better as I'm skimming through the Thomas opinion, where John Yoo is getting his ammunition. I'm really worried that that's, misreading what the chief is really doing. So.
Yeah, I mean, there's certainly something to be said, and I appreciate the excerpt being shared out on the Q&A piece, especially the last piece that was excerpt into the Q&A. When many of us were working with potential DACA applicants in 2012, many people had serious concerns, many potential applicants had serious concerns about whether to apply for DACA, because what it meant was that young people who knew they were not documented were essentially providing to the very same broader agency that had the power to deport them, to detain and deport them and their families, provided them with their name, their address, their school records, the place where their families may have lived. And so there was a serious level of contemplation that people had. Should I apply or not? The reason I bring this up is that for most attorneys, the kind of standard explanation and advice was, look, you need to understand this was a program that was created by the president. If in the future there were to be a president who were to be elected and who made it sort of his mission and his policy, a central piece of his policy agenda to deport undocumented immigrants and to criminalize immigrants, then you need to know that this could go away and you could be at risk. So that was the prevailing understanding. Now, part of that was lawyers trying to give sound advice, trying to give risk-averse advice, make sure that their clients understood what was going on. But certainly, yeah, I mean, the majority opinion injected a different way of thinking about how government and how agencies can undo action previously done. My memo, I think, is and I think in many ways is a recognition of just the tremendousness and the tremendous gravity of what DACA means, in particular for the communities who are affected, right? This is just sort of not any old government program created by memo, but when it has the stakes that are involved, then something more is required in terms of that reasoned decision making.
So I guess, I mean, is it possible, guys, that the DACA case and the census case, as opposed to how some portray them as just, hey, Trump administration, just stop lying, right? That what they really stand for are sort of maybe Chris variants on the emergence of the major questions doctrine, that the court is just going to apply different rules when it comes to administrative policies of whatever provenance, right? And from whatever sort of format, that have those kinds of systematic, we might say liberty effects, right? As opposed to just sort of, I don't want to say sort of lesser, but just distinct economic effects, right? I mean, and if so, is that sustainable in any meaningful way going forward?
Yeah, no, I don't think so. I don't think that's what Chief Justice Roberts, and this is really what is Chief Justice Roberts doing, right?
So much else about the court these days.
Yeah, I mean, I think it's really, and the census case is really another one where he's concerned about reason giving. He's concerned about the executive branch acting rationally and holding them kind of responsible to the reasons they do give. And I think that'll apply across the board and not just to kind of major questions. Quite frankly, I don't think in the census case, sure, that is huge. My guess with DACA is he probably wouldn't view that as more major than a lot of economic issues, just from its own. So I don't view it that way, but I do think both of those decisions are also just classic Roberts, creating some rules, but narrowing them in such a way that they really are going to be hard fit for lower courts and litigants to apply in other cases. I mean, the citizen question one in particular, I mean, it's all based on the lower court allowing discovery and the government agreeing to discovery. I mean, we would never even got there, right, without that, I don't think. And I think with the DACA, it's the government playing games in the Nielsen memo and not doing the dance, right? Instead of coming out and really.
Right, I guess, Chris, right? I mean, if the, let me put it this way: if the Duke memo, if it was in the exact same format, right? If it wasn't rulemaking, it was just a memo, but it had said, we don't think DACA is good policy, and so whether or not Obama had the legal authority to do it, we are rescinding it because we think our resources are better devoted elsewhere. We think enforcement is a waste of our, like, you know, if it had been 3 pages of policy objections to DACA, does this ever get to the Supreme Court?
No. Well, maybe it does. Maybe the lower courts still strike it down, right? But it would also have to have the paragraph that Nielsen has about reliance interest, obviously. That has to be there. And it might, Nielsen's paragraph might not be enough for Roberts, right? But otherwise, no, I think that you've got that would have been fine. Lower courts still might have struck it down, or, you know, but once it got to the Supreme Court, I think you'd have probably more than 5 votes, quite frankly. I don't know, Jennifer, do you disagree? Or?
Well, I was just sort of thinking about the question of would this have gotten to the Supreme Court, and certainly then the equal protection claims might have gone differently, and maybe with more justification in the original government memos and more of an explicit articulation of the motivation for the rescission of DACA, maybe then the equal protection claims would have been bolstered and had it. Anyway, it's hard to always, there's always another hypothetical to spin out. It is an interesting question, though. I mean, in terms of, you know, just major questions and how the court will grapple with them. And, you know, let's say, again, I'm sort of spinning out different scenarios, but like, let's say a future of legislative stasis on important questions of our day is what we have for the future, say even in a future administration. You know, you could see more decisions of national and pressing importance being made by the executive. And then that does raise an interesting question over how the court will respond, again, assuming that Justice Roberts continues to have his special place at the head.
So that's actually, it's a great segue to where I think we'll make the last question, Seth, and which I'll just put to the panelists very briefly. From Jim Wheeler, how much of the reasoning, if any, would you ascribe to broader political implications? Many observers of the court feel that Roberts' recent decision has been very much based on shielding the court from political fire. Do you think they played any significant role in how you came to this decision and drafted the opinion? I'll go first and say absolutely. And that, you know, anyone who tries to tell you that the Chief Justice's voting, especially now that he is the median justice, is not influenced by how he's reading the broader sort of relationship between the court and the country is selling me something, but I'm curious if either of you guys disagree.
I was just gonna say yes. I was just gonna affirm the question.
Chris, last word.
Yeah, I mean, absolutely. I mean, he's clearly aware of the court's institutional capital, and, you know, he had just months earlier sat on an impeachment trial. He's issued an unprecedented rebuke to the president about whether there are Trump judges and Obama judges. I'm not sure if this is the Chief Justice who Roberts wanted to be. I'm not necessarily, I think he always wanted to be Chief Justice, but I don't think he necessarily wanted to be making all these decisions that have a lot of political costs. I do feel like he probably feels this year in particular that he had to stretch a bit more than maybe he would normally like to in order to preserve the court's capital. I don't like to frame it in political terms. I think of it more in institutional capital terms. But I definitely think that's on his mind.
And I'll just say, and I think, I mean, the irony is, even with no changes in membership, right, I think the chief's probably a lot happier and more comfortable in a Democratic administration where he can just be himself, right, and not worry about sort of, you know, the court's institutional role to quite the same degree as I think he feels he has to now. But that's for another time, another panel. So let me just say, thank you, Jennifer Koh. Thank you, Chris Walker. Thank you, Federal Society, for hosting this. Thank you for those who stayed all the way to this point. And I think, Seth, there's information in the chat box about the next event. But I don't know if you wanted to say any last words.
Well, I'd like to thank you for filling in on such short notice. And as you mentioned, the chat box has a couple of things. A, who to contact if you'd like to become a member of the Texas Federalist Society. And then B, information about our next event, which will be loosely about the Netflix TV series, Tiger King. So be sure to register for that event. If y'all would like to come, you're welcome, of course. And next week, I've been assured that Professor Wasserman will be able to make it. So we're lking forward to hosting her as a moderator next Monday.
Great. Thanks, everybody.
Great. Thanks so much.
Thank you.